In March this year, the European Court of Justice ruled on a case called the Zambrano case. It was to do with Belgian citizen children in Belgium. So it was a very particular case of a Belgian citizen child with parents who were from South America, I think as far as I can remember, and their right to reside in the state. What the European Court of Justice said was that as an EU citizen in their own member state, the child should have the right to enjoy being an EU citizen in their own member state and not have to leave the European Union by the parents not having residency status. So it said that member states were pretty much obliged to grant residency status to parents of citizen children and to allow them the opportunity to work to provide for the child as well. People are confused as to who it applies to, but it's very particular to citizen children within their own member states. We're getting a lot of questions from people who have children in the state, children born in the state, but who aren't entitled to be Irish citizens. Therefore, they don't come in under this ruling at all. Going forward, the citizenship referendum, they removed the automatic right to citizenship, so that a child can only be a citizen under certain conditions, such as one of the parents being Irish, one of the parents being a UK citizen, one of the parents having refugee status, or if the parents were living legally in the state on a reckonable type of residency like a work permit or some kind of, let's say, not being a student, not being in the asylum system, some kind of reckonable residency for 3 years before the date of the child's birth. So if you meet those criteria, the child can be an Irish citizen, therefore they qualify under Zambrano. But an Irish-born child and a child born in the state, the confusion kind of arises that not every child born in the state will be entitled to be an Irish citizen. For somebody who is the parent of a child who's an Irish citizen, this is a huge development because, as well, justice came out on it very positively afterwards. Clears the situation up for us, we're going to react positively to it and grant residency status where we can. So largely they have been doing that in situations where maybe people don't have an immigration status for a start, they may be undocumented in the state, or there might be an international student on that very kind of partial type of status that now they can apply for a much better type of immigration status, or they might be on a stamp 3 as a dependent, or there might be a stamp 3 just because they've had problems with their immigration status. They can now apply for a much better immigration status. But one of the big implications of it as well, especially for single parent families, is that now anybody who has a partner outside the state, has a spouse in particular who's the parent of the child, can apply now to enter the state and join the family unit. Even if they were previously deported, they can apply to revoke the deportation order. They have to get a status that allows them to work, which is essentially stamp 4. So they get full residency status, which is great.
It splits up or it doesn't continue.
Yeah.
That mean then that the partner who came into the state now must maintain?
As long as they could prove that they were involved in the child's upbringing, so if they had access rights, if they had maintenance sorted out, if they could show that, even informally, that they had an arrangement whereby the child would be with one parent sometimes and the other parent some other times, if they could satisfy the Department of Justice that they were involved in the child's upbringing, that was enough, you know. They don't necessarily have to be a married couple, no, as long as they're a parent of the child.
Okay, thank you very much.